Oregon Divorce School. Every other week or so, I take a topic and do a deep dive into that topic on divorce law in Oregon. I've been a divorce attorney in Portland and Oregon for almost 30 years. Um, I've been doing this consistently. This is most of my practice, and I just like to spend some time talking about subjects that I know are important and that come up often. Tonight, we're talking about custody, parenting time, and child support, all of the issues connected to children. In conjunction with this webinar, next week I'm doing another hour just on determining custody. So this is kind of an overview of custody, but next week will be like a deep dive in how somebody wins custody. So we'll talk about custody, what it is, talk about parenting time, and then child support tonight. Uh, Agenda tonight is pretty straightforward. I'll introduce myself and then run through custody, parenting time, and child support. Like I said, I am Steven Leskin. I've been an attorney uh, in Oregon since 1992. My website and email address are on the screen. I don't take calls or questions during the webinar, but I am happy to answer questions if you want to give me a call next couple of days. I attended the seminar and I have some questions. Be more than happy to talk with you. Just let me know that you watched the seminar and we'll go over whatever's on your mind. All right, let's get into it. Custody. Uh, so, uh, Custody does not mean what you think it would mean. In a profession of smart, articulate people, custody is misnamed. Um, Custody means that you have possession of something. Custody usually means like possession. Like I have custody of my car, or I have, um, custody of, whatever property is, in my possession. That's what custody means. In the context of children during a divorce, um, custody means the right to make decisions about the child. Custody is more of a legal right to make um, decisions about the child. So custody doesn't mean possession; it means decision making right. So it's a little bit confusing. I don't know why nobody's come up with a better term, but the parent who has custody is essentially like the CEO of the family of the divorced family. Custody doesn't really exist in an intact family. Custody is a concept that applies to a divorced family. And custody stops when the child turns 18. So um, it only applies to minor children. In Oregon, there are two types of custody with three outcomes. There's joint custody and sole custody. And then with sole custody, obviously either mom or dad can have custody. Joint custody means that the parents can still work well together to parent a child, and that decision making going forward will be shared between the parents. Sometimes in a divorce decree, that custody is modified. So, for example, um, the divorce decree may read that mother um, has authority to make decisions regarding the child's health, or dad has uh, authority to make decisions about the child's religious education. So custody and sole custody uh, both mean decision making. Joint obviously means that it's shared. Sole means that it resides in either the parents, and custody can be modified in the divorce decree, uh, giving one parent a little bit more power or power over a specific area to make decisions in. So the authority of the custodial parent is to make any and all decisions solely for the benefit of the child, right? So uh, the parent who has custody has the legal right to make decisions about the child's education, about the child's religious upbringing, about the child's um, schooling, all of those things, all of those important things. reside to the custodial parent. The custodial parent may very well say, I want to share this. I still want to be a parent with the other party. And so they may go and say, okay, we need to make a medical decision in the best interest of our child. Perfectly fine, of course. But if there's no agreement, then the default decision making goes to whoever has the legal custodial power to make those decisions. So then the question comes up, what are the rights of the non-custodial parent? And those rights are information only, with one little caveat. So the rights of the non-custodial parent are informational. The non-custodial parent has the right to see medical records, has the rights to see educational records, has the right to see any other welfare type records pertaining to the child by statute, right? So whereas the custodial parent has all of those rights anyways, the rights of the non-custodial parent are limited to information about the child. The time when a non-custodial parent has decision-making rights is when the child is during the parenting plan is with the non-custodial parent, and those rights are a little bit limited. So, for example, the child is hurt and needs to go to the hospital. Obviously, the non-custodial parent has the right then and there to make decisions about the child, and um, that's unfettered. The uh, rights of the non-custodial parent in when spending time with the child or to do with the child, pretty much whatever they want to do. They can take them where they want as long as it's not otherwise indicated in the parenting plan. Um, so they have the right to be a parent. Uh, the non-custodial parent has the right to be a parent during their parenting time. Um, a non-custodial parent could not, for example, commit a child to a particular school on their own. That would be like within the rights of, like, supposing there's a private school and dad has custody, mom does is the non-custodial parent. Mom in that situation could not enroll the child in a private school and commit both parents to the tuition, right? Only the custodial parent would be able to do that, right? And so it would be up to the school to make sure that they have, something showing the divorce decree if the parents are divorced, and showing that the mom or the dad has custody. Um, Next question is, how is custody determined? And like I said at the outside, next Thursday, um, we will be doing an in-depth, a really in-depth uh, uh, webinar on determining custody and how the courts determine custody. And we will take a deep look at the Oregon Revised Statute 107135, and we'll go through how the courts use that to determine custody. For our purposes now, I will say that custody determination comes down to a best interest of the child analysis. And then the legislature has set out specific criteria. For example, child's relationships with others, how the child relates to the other parent's family. Is there abuse in the relationship? Those are just some of the factors that are considered in a best interest analysis that the court needs to use to determine which parent will get custody. An award of custody is not static for the life of the child. Under certain circumstances, the custody of a child may change over time. In order to do that, the parent without custody, the non-custodial parent, has to go to court and prove two things. One, that there's a significant change of circumstances such that the current judgment is no longer appropriate. And two, that the proposed change is in fact in the child's best interest. So significant change, and the change is in the child's best interest. And so, for example, um, dad has custody and starts drinking, and then starts drinking with the kids in the car and has a Dewey. that would be grounds for that would certainly be grounds for changing custody, a parent endangering the life of a child. All right. So custody is um, a concept, right? It's like who has rights to the child, right? And who has decision-making right over that child, right? It's a concept. A parenting plan is the physical manifestation of where the child will be spending time, right? Parenting plan allocates a child's time between parents. And so that allocation of time uh, and other details is what's in the parenting plan. So what a parenting plan does is it lays out where the child will be, what time one of the parents will pick them up, where they'll be picked up, um, what are the details surrounding pickup and drop-offs. There's oftentimes a lot of friction at pickups and drop-offs. So it could be that, you know, mom can't come within, 100 feet of dad's house, or child is dropped off at the curb and can walk to the, parent's house. Um, so parenting plan dictates all of that. Uh, Parenting plans are also age and developmental specific. So obviously, a plan that's designed for a 4-year-old or a 6-year-old is not going to apply to a 13-year-old or a 14-year-old. So it's anticipated that just the natural growth of children is a change of circumstance, and that a parenting plan will be updated periodically. Uh, there are changing gears just a little bit. There are sources of parenting plans. So, for example, you could go to the Oregon Department of Justice website and type in parenting plans, and that will give a number of very, very well developed Oregon forms, Oregon fillable PDFs that cover all of the details of a parenting plan. Uh, Usually the forms in Oregon are, kind of so-so. These particular forms are very, very good. They're very well thought out. They're laid out well. They work well. They work the way they're supposed to. And I actually often use them in my practice with people to help develop a parenting plan. So, and you can find at the Oregon Judicial Department. I think I said Oregon Department of Justice. That's not right. It's the Oregon Judicial Department website. There you will find parenting plans there. Um, and you will find age-specific parenting plans. So for toddlers and teens and older. Um, Rights of children under the parenting plan. So the short answer to that is young children have no rights under a parenting plan. Uh, Kids have no say in whether or not they can observe the parenting plan. The parenting plan is for the parents, and um, a kid cannot throw a temper tantrum and say, "I don't want to go to mom's house," or "I don't want to go to dad's house," and the parents say, "Well, that's okay. You don't have to go." If the parenting plan dictates that the child goes to mom's house, the child goes to mom's house. That loosens as children get older. So you're not going to take the same hard, absolutist view with a 16-year-old as you are with a 6-year-old. As kids age and mature and become able to articulate for themselves what they want, uh, parenting plans usually tend to show more flexibility for the child's preferences and choices. Uh, for young children, it's not appropriate for the child to say, "I don't want to go." Whereas for 15-year-old, 16-year-old, certainly a 17-year-old, um, a parent's not going to force a 17-year-old to go to the other parent's house if they don't want to. So the rights of a young child does not exist under a parenting plan, but it does as the child ages. So let's talk about some um, best practices in creating a parenting plan. When I when I create a parenting plan for a client, my first question is, what are the child's interests and what are their values? And um, I'm asking that about the child, but I'm also asking that about the parent. I view parenting plans as a great way of the parent helping to prepare the child for adulthood. I see developing parenting plan as a way to help convey a parent's values and their interests. And I want to see a parenting plan that allows the flexibility for a, parent to be involved in ways that maximize their involvement by finding their values and their interests and being able to express that to their kids and help their kids develop those values and grow into uh, self-sufficient, balanced, healthy adults. And so maybe for not so much for young kids, but for certainly, kids who are, 10, 12, I want to see that the parents have time, both parents have time to do meaningful activities with their kids. And I want to see that built into the parenting plan so that there's flexibility. So, for example, one parent wants to teach what likes fishing and hunting and outdoor activities. Uh, I want to see that the parenting plan allows the parent to have time to do that. And then I will emphasize to the parent, to my client, that that's your time to teach, all of those things, all those outdoor um, activities teach self-sufficiency. They teach basic survival skills. They teach responsibility and learning to do chores and learning to take, learning what it means to have other people depend on you. And so that's what I mean by, using the time in a meaningful way to teach your kids life lessons. And so that to me is like some of the ways that I think about like how am I going to create a parenting plan that works into the future for both the child and the parent. And also it has to accommodate both the child's interests and the parent's interests. And it has to do that in a way that keeps both involved, right? Like if the child doesn't want to go, camping, then, the adult has to show some flexibility also. If the child wants to say, doesn't want to go camping and wants to stay at home to work at a science project, hopefully the parent will show some flexibility. But I want that built into the parenting plan, right? But it's got to be something, let's try to find those areas where there's going to be overlaps in interest, and that keeps the parents involved. Um, I see a lot of cases where, mom and dad are having a falling out, they're divorcing, and dad's a good guy or mom's a good person, and they just want to cut the child off from the other parent because they're hurt. And that's a, reasonably common scenario. And there's no safety issues, no drug issues. Um, and it just, out of spite. And to me, that's the worst thing you can do is denying the child their relationship with their parent. And if a parent wants to be involved and do the work to raise a child, that's got to be encouraged, not taken away. And so I encourage, particularly where there's, I see that dynamic going on. I want to encourage the parents say, this the desire to stay involved with the child is a good thing, and that needs to be nourished and nourished so it continues to grow. I went backwards. Now I'm going forwards. So parenting time continued. So in addition to the allocation of time where the child's going to be, when they're going to be picked up, when they're going to be dropped off, what holidays they have with either parent. There are other clauses that can typically be written into a parenting plan. For example, um, a parent smokes and the other parent objects to that. You can write into the parenting plan that the smoking parent will not smoke um, while the child is in the presence of that parent. Same thing with intoxicating, with whether it's marijuana or tobacco or alcohol products. You can certainly put in a clause that says the parent will not engage in these activities in the presence of the child, or particularly with alcohol, may not drink an hour before or 2 hours before parenting time. I'll come back to enforcing that in a little bit. It's not enough just to put it in. There has to be an enforcement mechanism and a monitoring mechanism too. Uh, but that type of clause is certainly not unusual. Another common clause that is found in parenting plan is a non-disparagement clause. Uh, Parents can't talk ill about their children to the other. They can't talk ill about the other parent to their child. And you hear that a lot. That mom said this about me, um, dad said that about me. It's not cool, and kids should not be subject to that. I personally think that is damaging to children, and it when I hear it, it makes me angry that somebody's doing that. But you can't put that a into the parenting plan. Enforcement can be difficult. What are you going to do? Take the court. Mom said to the child that I'm a deadbeat. What's the court going to do with that? That's kind of harder to enforce, uh, but certainly that can be enforced um, uh, through the parenting mechanisms that we'll talk about in a bit. Travel restrictions. Um, if you're in Portland and you take a child to Vancouver, that's not usually an issue. But taking a child, outside of the state or on international trips, oftentimes there'll be a clause in the parenting plan that says no travel without the other parent's written permission. In order to take a child out of the country, both parents have to sign off on the passport. Um, so that's not necessarily um, so uh, what sometimes the parenting plan will say is that uh, parent dad anticipates going overseas, and dad will notify mom in writing, and mom will help with the travel plan. So, for example, mom will sign the passport or whatever other documents are required to get the child to travel overseas. But that's also a reasonably common uh, clause in a parenting plan. The other thing that you see is child with special dietary needs or medical needs. Um, those sometimes are laid out in a parenting plan that both parents agree to cooperate with the child's specific diet or medical, or specific medical needs. An issue that's come up, it's kind of lulled a little bit lately, but a couple of years ago, gender issues were coming up a lot. I think my child is trans and I want to be supportive, but the other parent doesn't. And so there may be some discussion about that either in the parenting plan or as part of the judgment, what the what both parents are willing to do or not do, or um, how they're going to be supportive. Uh, Sometimes that will get written into a parenting plan also. Lately, I haven't seen that so much, but that was, coming up fairly often 2, 3 years ago, is, how particularly if parents are not on the same page. If somebody's a little bit more conservative and not as flexible with their views of gender, then that obviously will cause additional friction between the parents. Those issues may also be grounds for changing custody. A child grows up and says, you know, uh, I think I'm really a girl. And um, mom doesn't support that. And dad says, well, if you can't support it, you're not acting in the child's best interest. And so that may get litigated under a best interest of the child to change custody, right? That then becomes a custody and decision-making issue, not necessarily a parenting time issue. Safety plans. Suppose there's been violence in the relationship, or there's been alcohol or drug abuse. Under certain circumstances, um, a court will require that the parents, the offending parent, will have a supervisor to supervise their parenting time. Usually it's a professional supervisor. Sometimes it's a family member, but usually it's a professional supervisor who is not otherwise involved in the family. You can go online and finding those people. And sometimes there's, we agree to use so and so, or we agree to use somebody off of this list. Uh, and the court will say, okay, so dad gets parenting time up to 3 hours once a week in the presence of this professional supervisor, and dad has to pay for it, and it'll be cost-free to mom, and the supervisor gets to decide where the supervision will, the parenting time will be. Uh, and so all of those issues may get fleshed out in the parenting plan, but it is possible where there are safety issues for the court to award supervised parenting time. In the event of alcohol abuse, drug abuse, people will use a product service called SoberLink, and SoberLink will monitor for alcohol. I don't remember if it's also marijuana. It might also include marijuana. Uh, um, use. So people will say, uh, "Mom has a mom is an alcoholic. She's been in AA for years. Mom still occasionally drinks." Dad may say, "Okay, I'll grant you parenting time as long as you take a SoberLink, blow into the SoberLink app um, an hour before parenting time, and if it comes back clean, you can have parenting time. If it comes back at all uh, showing alcohol consumption, then you lose your parenting time for that day." Or, you know, mom has the kids over the weekend, and the mom has to blow into the Silver Link, Saturday or Sunday or some other set or random points. So SoberLink is used as a monitor, and um, that's used fairly commonly. I think the SoberLink use is actually kind of expensive. I think it may be as much as 150 a month. But if that's an issue, you can look it up on the SoberLink website, and the SoberLink website will send a report to the other parent so that they can know that the offending parent or potentially offending parent is, clean, sober, and in a capable state to do the parenting time. And that is not uncommon. If you were to go to court about that, the courts will certainly be familiar with that issue. When there's been, particularly when there's been violence in the relationship, um, couples will use a product called My Family Wizard, which is a communication app and will track communications and um, highlight inappropriate uh, relations. And that just narrows um, the communication between the parties into one app so that there's not, phone calls and texts and other communication. The parties agree that everything will go through My Family Wizard, and that way there's a record. If the case goes back to the court or goes to court, the parties can say, okay, here's where dad was yelling at mom, or here's where dad flaked out, or here's where mom, admitted that she didn't pick up the kids in the morning, right? So My Family Time serves that as that purpose, as a document, a way to document the conduct of the parties. All right, here's my final thoughts on parenting time. So every couple, every relationship has its rules that evolve over time, and they become pretty ingrained. And I sometimes think that like divorce doesn't really change that underlying dynamic. Um, but what I tell my clients is that parenting time are negotiated rules that are enforceable. And to change that dynamic, all you have to do is enforce the rules. I don't want to minimize what that entails, but it's a way of saying if dad is, consistently flaky, and mom just like, is at wit's end. Mom has with a well-drafted parenting plan, mom now has options, right? She can change the rules of the game by enforcing and choosing to enforce the parenting plan. So it's a way of changing that script. And that's the way I like to think of parenting plans. That it's we have negotiate like in our relationship, we never had negotiated rules that were reduced to writing and signed. Now we do, right? And so maybe the dynamic was abusive, maybe there was a power dynamic, and mom had just gotten beaten down over years, or dad had gotten beaten down over years. The parenting plan, at least as it pertains to the kids, is one way to change that dynamic, right? And the courts, there's an expedited uh, process through the courts to enforce parenting plans. And so it's not, it doesn't necessarily have to be the big, court Megillah that people went through to get custody or to divorce. You can call the court and say, how do I do the expedited parenting plan enforcement? And you get the forms for that, and you go to the court and say, dad consistently doesn't show up on time for parenting, right? So there's ways to do that. The other point that it's not on the screen here, I just thought of it, but it actually really is one of the most important points about parenting time and parenting plans is that the parenting plan is a minimal guarantee of time with the children. So that means that if the parents are getting along well and they're communicating and they're both getting time with the kids and dad wants to take the child skiing on mom's weekend, he can call up mom and say, do you mind if I take um, Roger out this weekend? And mom says, yeah, I don't have a problem with that. I kind of want to go out with my friends. Uh, if the parties can get to that place of flexibility, or when they get to that place of flexibility and trust, and they realize that their cooperation is beneficial for the kids, the parenting plan doesn't matter. A parenting plan is only in place to protect both parents when somebody is being slighted, or the child is being slighted and not given a full opportunity to have a relationship with a parent. If parents are getting along well and they're able to say, can we make this change? I want to take some time off during the summer and take the child away. Would you mind if I took the child for an extra week so we can travel across Canada? The other parent can say, certainly, have fun. Or you can say, no, we agree that you only have the child for 2 weeks during the summer, and I'm not going to allow a third week. So if there's flexibility and trust and um, a mutual respect for each other and the way the other parents, then the parenting plan doesn't matter. Nobody is going to come out and enforce the parenting plan if the parents are happy with it. There's no third party who's monitoring the parenting plans for compliance. All right, we are going to switch gears to child support. So, um, there's child support and spousal support, and there's a key difference between the two. As we will see in just a moment, child support is set by statute. You can argue about the inputs, but you can't argue about the output. So, child support is a determined amount determined by a statute. Spousal support, on the other hand, the amount of money that one party will pay to the other party for maintenance for life, for help getting by in life, or for transitional support is a negotiated amount. Um, while the numbers for child support and how it's calculated are very specific, there's very scant guidance on how much the courts can impose for spousal support. So, spousal support is a negotiated amount. Child support is an amount set by statute, and that is crucially important to understand. Child support is not optional in most circumstances. Um, and the really brilliant thing about that is that it means that people aren't arguing over how much support they need to pay. right? So maybe dad doesn't make a lot of money. He loves his child, but he doesn't make a lot of money, and he can only afford so much. That amount is determined by statute. So that those kind of dynamics are removed from child support negotiations. So um, child support is set by statute. It's not really. It can be um, modified, but only to a certain degree. And everybody is obligated to pay some child support where appropriate. So uh, um, the entity in the state that enforces child support is the Oregon Department of Justice. Child support can also be enforced through the local district attorney's offices, but it's the Oregon Department of Justice that administers child support programs. So, for example, um, parties agree that in a divorce, parties agree that child support will be paid through the Oregon Department of Justice. The Department of Justice will issue orders to collect the spouse support through wage withholding or other mechanisms if it's not being paid. Uh, and um, Parties can agree that they'll pay child support directly to one another, but it's they can also do it through the state. So the Oregon Department of Justice does have a very, very large role in collection, accounting for, and enforcement of child support awards. You can go to the Oregon Department of Justice website. You'll see the tab for child support, and there you will find the important child support calculator. And the child support calculator dictates how much child support will be paid. And the inputs include number of overnights, income of both parties, then some other factors such as are the parties receiving or paying spousal support? Are they paying union dues? Are they is the child receiving either Social Security or veteran benefits directly? Um, and then the other questions involve medical insurance and who's paying for health insurance, I should say. So um, once those inputs are put in, it gives back a number, and that's the number that parties obligated to pay. There's under certain circumstances, um, the parties can agree to modify that or not pay, but those statutes are very limited. Um, those opportunities to modify are pretty limited. Uh, but the important thing what the courts will look for is that there is um, a mechanism for payment of child support. For example, a couple of years ago, I did a divorce where a wealthy family, no question it was a wealthy family, husband was transferring to wife seven paid off homes that were all rented, right? And that was obviously going to take care of the child support obligation. So the court in that case was, we don't, we'll waive child support. You still had to do the calculation and show what it would be, but there was a mechanism for paying child support built into the dissolution of the marriage. Um, the last thing about child support is enforcement. And the Oregon Department of Justice enforces child support awards, and they have a lot of power to do that. They can collect tax returns and tax refunds. They can garnish wages. They can seize bank accounts. They can suspend professional licenses. Uh, there's a compact between the states so that if you have a child support award in Oregon and the person who's obligated to pay lives in New Jersey, New Jersey will do the collection efforts for Oregon and vice versa. So there's a lot of uh, and those compacts are under federal law. So there's a lot of enforcement mechanisms uh, to enforce a child support obligation. Uh, there's also a crime of failure to pay child support. In my years of doing that, the only time I've ever seen that independently enforced is when it's coupled with another crime, like, for example, child neglect. Uh, it's not a standalone crime. It will always come with another um, crime associated with the child. All right, we are kind of coming to an end here. Um, child support issues, child issues are the most important and complicated part of a judgment. Uh, Custody is often heavily contested and can be the most contentious part and the most hurtful part of a negotiation. I have seen parents, and it's not a question of who loves the child more or anything like that. I've seen parents um, fight with everything they have in them to get custody. I've seen parents walk away from that same fight saying, I don't want to fight about this. I think the fight itself is wrong and will harm the child. Um, Sometimes parents have to fight for custody so that they believe that they know that the child will love them. I don't know that that's true or not. But you see all kinds of dynamics that are not always surface apparent when custody is challenged. But it is one of the most important things I do as a divorce attorney, and sometimes will take up the most time and most money to prepare for a custody fight. And it can be the most contentious part of a negotiation. The standard is always going to be best interest of the child for determining custody and how a parenting plan is devised. And in considering best interest, courts really do look at conduct, right? They want to see that, somebody's involved. They want to see that they're doing positive things in making a custody determination. And likewise, they don't want to see the negative things that sometimes happen, like drinking and driving, or drinking and driving with the kids in the car. So that is all about children. I encourage you to join me next week or 2 weeks from now when I do a really, really deep dive in determining custody. Again, if you have questions, I am more than happy to take questions. If you want to give me a call at the office or shoot me an email, here's my contact information, and uh, happy to have the response and the questions. Thank you for joining me tonight, and I hope you found this informative and I'm not going to say enjoyable, but at least informative. So thank you for joining me tonight.